This is Tom Taranto, and welcome to the Tom Taranto Show. I'm really excited about our guest today. Amy Van Fossen is a local elder law attorney here in our area. Welcome to the show, Amy.
Thank you for having me.
Just wanted to let you introduce yourself. You want to tell our viewers and listeners what you do?
Sure. I'm Amy Van Fossen. I'm a Melbourne-based elder law attorney. I do estate planning, VA, Medicaid, probate, and anything to do with elderly people.
Question that we were talking about, and I think to bring some value to our viewers and listeners, we were talking about how many people roughly have no estate plan. They don't have a will, they don't have a trust, they don't have a power of attorney. I mean, what would you say in your guess, percentage of the population that has their stuff together?
I would say about 30% of the people that come into my office do not have their documents in place. Whether it's their children come in and we need to go through the probate process for mom or dad and they passed away with no will, or it's a middle-aged couple that just need the basic documents, and sometimes elderly people have never had a legal document at all, and they come to my office in their late 80s thinking it's finally time to do a will. So it's a pretty low percentage of people actually have their documents in place.
So you think like 30% have it together, which means 70%
do not have it together.
Do not have their stuff together. And in my experience in real estate, I've seen so many cases where it becomes a real serious problem. And I think the same thing, it's a huge percentage. So really of importance for that 70%, get it together. Because what can happen if they don't? What can happen if something happens to one of the spouses and they don't have their paperwork together?
Well, if you don't have a really good durable power of attorney, and I'm a Florida licensed attorney, so in Florida we have very strict rules on durable powers of attorney. So if a husband and wife do not have powers of attorney for each other, and for whatever reason the home needs to be sold and one of the spouses no longer has capacity, the only way for the house to be sold is to go through the guardianship proceeding. A guardianship proceeding can cost thousands of dollars depending on how complex it is, but it could easily start between $5,000 and $10,000 just because they didn't have a simple durable power of attorney in place. I had that happen with a client years and years ago, and the husband had to get guardianship of his wife because the house needed to be sold in order for them to move into assisted living. The wife was really struggling health-wise, and went through the guardianship proceeding. It was probably $6,000, $7,000. They went to a different law firm, and right after the guardianship was awarded, the wife passed away. And so generally everybody owns, if they're married, joint tenants with right of survivorship is how they hold the property. That is okay. If one passes away, it transfers to the other, but it doesn't deal with incapacity. And so step one in my office is always, where's the durable power of attorney? And furthermore, as a Florida attorney, we see powers of attorney written in other states, and parts and pieces may not be valid in the state of Florida. Specifically, we want to see that you can specifically deal with real estate. And so if you have an old power of attorney from another state, if you have a power of attorney written in Florida prior to 2011, because there was a sweeping change in the law, we suggest that they redo the powers of attorney with an attorney who understands estate planning.
So what do you think is the reason for that 70% or so that just don't have it together? What is the resistance to going and planning their estate?
Some of the resistance, I think, is they assume just because we're a law firm, we're going to charge thousands of dollars for a simple power of attorney. Sometimes they're just hesitant. They're very nervous about coming in. A lot of our older women have never dealt with business or any type of business situation. Their husbands had always taken care of things. So there's a hesitation. I think they also think they'll never need it. They're going to live forever. There's never going to be an incapacity. We're never going to have a car wreck, those kinds of things. So, and just the fear of the unknown.
Yeah. Well, I think too a little bit when you start talking about a will, it's almost like, if I write that, I'm going to die because I'm planning for my, and it's, and I also have had people give me the impression that, well, I'm not wealthy, so I don't need to go to someone and get these things done.
Exactly, and they're not usually that expensive if you consider the ramifications of not having them in place. Yeah. So a law firm could charge, $300, $400, $500 for a power of attorney. The alternative is a $5,000 to $10,000 guardianship. And every law firm is different, every market is different on the pricing. It just seems in Brevard County that's about the average. If you don't have a will in the place, the state of Florida will tell you who your beneficiaries are, and you may not like those beneficiaries. Right. So in Florida, you only have to leave property to a spouse and minor children, and beyond that, you can leave your property to anyone.
I was thinking about what you said about a spouse being having a power of attorney. I talked with a man who his wife was incapacitated, And he said, his argument was, but it's my wife, we've been married for 50 years, I should be able to sign for her.
Right.
And he felt that way, but legally he was stuck. There was some kind of benefit he wasn't able to get because they didn't have that.
Exactly. And so maybe 40, 50 years ago, you could do that. Maybe in other states you can do that. But Florida is very strict. We have so much elder fraud in the state that the state has just clamped down on the powers of attorney. They don't want anyone to act for you legally unless you have it in writing. So again, even if you're married 50, 60 years and you need to sell the marital home, you're going to guardianship court. There's really not a lot of way around that. A title agent is not going to allow a husband to just sign for a wife unless there is a power of attorney in place and a good power of attorney. You know, it has to be signed in accordance to Florida law. Some people just sign it and have it notarized, and it's not really valid. You know, and so there's different ways to sign it and to make it a valid document. Title agents, when you go to sell the home, they're very strict about powers of attorney.
Yeah. So there was a case that I came across where the man, his wife became incapacitated. He needed to sell the home because he needed the money to make a move to be closer to the children, and he couldn't even list the property because the wife needed to sign it, and he had nothing. And the money it would take to get everything done, that money was in the house, so it was a catch-22 and a really sad situation.
Exactly. And so you don't have the power to act legally for anyone, whether it's a spouse or a child over 18, without the proper legal documents in place. So again, a simple power of attorney can save thousands of dollars in legal fees after the fact.
Tell me about a trust. So what are the benefits of having a trust? Do you feel like every family should have a trust?
I'm very pro-trust. I like trust, even though I do a lot of probate. Attorneys make a lot more money on probate than they do on revocable trusts. And every attorney has a different preference, but I'm very pro-trust. If you own real estate, it's a great idea to have a trust. If you put that house in a trust, it can avoid probate. So all I need is a death certificate, and I can deed the house out of the trust to your beneficiaries. The alternative is a will, and if you have a will, that's great. Your property will transfer to your children, but there's a really good chance we'll go through the probate process.
And that is long and expensive, usually?
In Brevard County, it could take over a year. We have a very large percentage of senior citizens in Brevard County, and so our probate judges are very backed up at this point. And it could take 7, 8, 9 months before the judge allows the sale of the property. So you're not allowed to list the property until you get the judge's blessing as well. Okay. And it just drags out forever sometimes. We went from one probate judge my entire career to now I believe we have 4 probate judges. And even though the laws are very standard, sometimes they have their own little nuances that they like to see in the documents. Probate, everything is electronically filed, which things can get lost in the electronic filing things. So probate can take forever, and it is expensive. And again, probate in my office is always more expensive than a trust. Having a trust and then putting your assets in the trust makes things a lot easier down the road. Absolutely. So, okay, definitely. And a lot quicker. Your children can literally, with a trust, we can sell the house the next day that we get the death certificate. Okay. If not, we're waiting for the judge to give us permission to sell the house, and it can be 7 or 8, 9 months before we're allowed to sell it. So in the meantime, the kids are paying the HOA fees, the taxes, the insurance, the electric bill, the pool guy, the lawn guy. And so as long as your kids have got plenty of money to pay those expenses on the house just sits until the judge gives us permission to sell it. Again, with a trust, we can sell it within 5 to 10 days of someone passing away. So it's like paying a smaller amount up front or a lot of headache and a lot of hassle later. Absolutely. I had an experience where it was a gentleman who got sick, single man, owned a condo, and it turned out that he passed away pretty quickly, but there was still plenty of time where he could have done something, and it ended up having to go through probate. Nothing was done. He didn't deed it to his children, didn't put it in a trust while he still had capacity. And then the whole thing had to go through probate. And I felt like, to me as a real estate agent, it made sense that something should have been done before he passed away. But I guess the average person maybe just didn't know. They just waited. Right. We do a lot of crisis planning. On occasion, we will go to a hospital to have things signed if needed. We have to take an entire team. We have to have a notary and 2 witnesses in order to get the documents done. Deeds can be done very quickly. Trusts can be done very quickly as well. And it's imperative. So it's not like we don't get asked to do these emergencies all the time. It is something that we have the time, we'll do it. If we don't have the time, we'll still do it. And so it's unfortunate that that family didn't know you know, who to call, who could make it happen. I mean, we can put other work aside for a little bit in order to get that emergency taken care of. It's an easy fix. I rarely deed houses to kids because it could cause problems in the Medicaid and VA process later on if mom or dad have a medical crisis and we need to look for public funding. By deeding the house to the kids, it could cause penalties, could deny benefits from Medicaid and VA. So
you put it in the trust?
I would rather put it in a trust all day long. You can continue to get the Medicaid and the VA benefits by putting it in a revocable trust.
Okay. What do you think about people who want to save a little money and they go online and they download forms and they try to do it themselves?
Well, attorneys make a lot of money fixing it. So just to let you know, in the long run, you're probably not going to save a lot of money. I also see that they do them incorrectly. So where they thought that one kid could get a house and another kid could get a bank account, they don't write it correctly. Right. Even though the forms are walking you through it, there are nuances that we pick up on and make sure that your wishes are done exactly the way you wanted them. Just because you can pull up a form online and type doesn't mean that your ultimate, what you wanted to happen, would happen.
Yeah.
And so we unfortunately end up going to probate a lot of times. We end up in the guardianship process a lot of times. I had a lovely engineer here in Brevard County, which we have tons of engineers, pulled a power of attorney online for his dad, and we've now gone through the guardianship process because it wasn't done correctly. We've now gone through the probate process because it wasn't done correctly. So thousands of dollars in legal fees because he didn't want to pay for a power of attorney done correctly. And so he learned the hard way. You know, I also don't like forms that you get at like a local office supply store. They have just a ton of different problems within them as well. The state of Florida on durable powers of attorney are super strict. We have what's called superpowers, and they usually are not encompassed in a document you can get, you know, from an office supply store.
So if somebody did want to get a hold of you and check out your services, how would they do that?
They can call our office. It's 321-345-5945. We also have an online site, amybvanfossen.com. I do a seminar every week on either VA benefits or basic estate planning, and so the seminar should be listed on our website, and it's a free seminar. If you come to this seminar, you get a free half-hour consultation with me as well.
Wow, that's awesome.
I try.
Well, thank you very much. Thank you so much for coming out today. I appreciate it.
Thank you for having me.
Thanks.